saw that, they handed down the case that is allowing the gerrymandering, and we know that, a batch of cases. And one of the cases that they're sitting on, that they're going to release something any day on, is the removal of protective status for Haitians and Syrians in particular. And there's a reason this is very interesting that this is happening with this Supreme Court. So Supreme Court mulls Trump administration push to end protections for migrants from Haiti and Syria. Scroll. Colin, thank you. Okay.
Now you know how it feels.
Yeah, but how do I say it? Nobody in there would be yelling "Free Colin" for how I say it. The Supreme Court on Wednesday wrestled with the Trump administration's push to end legal protections for migrants fleeing war and natural disaster, hearing arguments that offer the latest test on how the justices will assess the legality of the president's far-reaching crackdown. This is so infuriating. Several conservative justices appear to be leaning in favor of the Republican administration's argument that the law limits what courts can do with a program known as temporary protected status, or TPS. The outcome could come down to Chief Justice John Roberts and Justice Amy Coney Barrett. The government is appealing the lower court orders that blocked the Department of Homeland Security from immediately ending the TPS status, or TP status, for people from Haiti and Syria. If they agree with Donald Trump, authorities potentially could strip the protections from up to 1.3 million people from 17 countries, exposing them to possible deportation. Continue. The court has sided with the administration before and allowed the end of the program for people from Venezuela as lawsuits continue to play out. Is that the end? Okay. The Department of Justice argues that the Homeland Security Secretary has the power to end the program and that the law bars judges from questioning those decisions. The kind of determination that is at issue here is just the sort of determination that lies kind of at the heartland of what has been traditionally entrusted to the political branches. What a bunch of fucking word salad, John Sauer. Fuck. Okay. Lawyers for about 350,000 migrants from Haiti and 6,000 from Syria say the government short-circuited the process and that judges can consider whether authorities followed all the steps laid out in the law. Since Trump returned to the White House in January, DHS has ended the protections people from 13 countries, some of whom have lived and worked in the U.S. legally for more than a decade, have lost jobs and housing in a matter of weeks. Returning to Haiti and Syria is out of the question for many people because those countries remain wrecked with violence and instability. Wonder how that happened there. Well, one can't even begin to understand that. This really is life or death. 4 Haitian women who were deported from the United States in February were found beheaded and dumped in a river several months later. The administration appealed to the High Court. So they lose on their ability to be bigoted pieces of shit, and then they double down. Okay. They appealed to High Court after New York and District of Columbia agreed to delay the end of protections. One judge found that hostility to non-white immigrants likely played a role in the decision to end protection for Haitians. You think? You think so? During his campaign, Trump amplified false rumors that Haitian immigrants were abducting and eating dogs and cats in Ohio, home to a large community of people with protected legal status. Haitian people are here. They are homeowners, business owners. They're working. They are paying their taxes. So there will be a big impact in the economy. Operations manager of the Haitian Community Health and Support Center. Scroll. Okay. Federal authorities have denied that racial animus played any role in the decision of removing legal protections. They cite a Supreme Court decision from Trump's first term that rejected bias claims based on social media posts and upheld the travel ban on several Muslim majority countries. Roberts questioned whether that administration is asking for a significant of expansion of the decision he wrote in 2018. And here's where it gets very interesting. And I pulled up a picture, okay? Barrett, who has...
Coney Island?
Well, so this Supreme Court justice, that's her and her family. Do you notice something about two of her children? Yes. Anything look interesting to you about two? Which one of these things is doing their own thing kind of thing? The two of her children look a little different. That's because she has two children adopted from Haiti. Okay. And she is now has to make this decision. Okay. You could pull it away, Colin, because I'm going to explain it in lay people terms for the people as to what this is and what we're dealing with. So basically, the best argument that the state attorney has, or that the Solicitor General who's arguing on behalf of the Trump administration, the best argument is that the Supreme Court doesn't have the authority, that this is within the executive branch. So he's arguing it just based on the very limited scope, which the Supreme Court does have limited scope, and that this is just really outside of their jurisdiction, that they really don't have the authority to be involved here. Okay, that's what they're arguing. Okay. And this is where I'm going to get back to when we were talking about lawlessness before. And I think this is very, very important. We are lawless. We're lawless. Okay. So right now, this is an appeal regarding the Supreme Court, and specifically Amy Coney Barrett, because in fact, you are a mother to two Haitian children. I get what the technical parameters are of SCOTUS. I get it. And if these were normal times and we were living in the world where the court wasn't political, where everything wasn't upside down, where the corruption didn't just ooze all over the place, and we were really a lawful type of people and system, then I could see the argument of the Solicitor General. And I would always have been one of the first people to stand up and say, that's not within their jurisdiction. We need to stay within the Constitution. That's not the Supreme Court's jurisdiction. I am so far past that now. And it's it is such a moral thing at this point that it just looks silly that the solicitors arguing about their procedure when we're talking about the lives of these people. It's infuriating to me. And I cannot fathom how somebody who could be the mother of two Haitian children would put that aside.
Well, maybe
what their procedural stuff is.
Well, maybe they're her house servants. I mean, you never know.
No, those are her children. I know they're her children.
We're going
to talk about adopted children from Haiti. Those are her children.
If we're talking about the Supreme Court, we might as well address this. So the U.S. Supreme Court under Roberts takes wrecking ball to the Voting Rights Act. This obviously is a big deal. We knew that.
This is the gerrymandering. I mean, yeah. This is essentially undoing any protections that, minority groups had in terms of being completely washed out of the voting, having their voices heard.
Let me tell you something. The Democrats are going to regret what they pulled in Virginia. Because if you think that the Republicans will not come back twice as hard, you're nuts. That's what they do. And that's what they are doing. The Voting Rights Act of 1965 has often been called the crown jewel of the U.S. civil rights movement, but under a U.S. Supreme Court led for 2 decades by conservative Chief Justice John Roberts, experts said that jewel has lost its luster. In a 6-3 ruling on Wednesday, powered by its conservative justices, the court gutted what scholars said was the last remaining pillar of the landmark law enacted after the Bloody Sunday March in Selma, Alabama, with the aim of preventing racial discrimination in voting. The metaphor is a wrecking ball, said Rick Hassan, an election law expert at UCLA, describing the Roberts Court's approach to the Voting Rights Act, or VRA. There are still parts of the VRA that are operative, but the 2 main pillars are now virtually dead letters. Those provisions include Section 2, subject on Wednesday's court ruling, the decision which blocked an electoral map that had given Louisiana a second Black majority U.S. House representative district. will make it harder for minorities to challenge electoral maps as racially discriminatory under the landmark civil rights law. The ruling was issued with congressional elections looming in November as President Trump and fellow Republicans fight to maintain control of both the House and the Senate. Trump hailed Wednesday's ruling and said he thinks Republican-led states would now want to reconfigure their voting maps. Obviously, they're all going to do it. Every Democratic state, every Republican state, they're all going to do it. You can kiss primaries, or you could kiss competitive elections goodbye now. Everything's primary elections going forward. That's the way it's going to be. Supporters of the ruling include John Yoo, who served as a Justice Department lawyer under Republican President W. Bush, said it continues the court's campaign to ensure that the government obeys a color-blind constitution. A sharp dissent authored by Justice Elena Kagan and joined by her two fellow liberals.
I resent that phrasing. Thank you.
Which?
Two fellow liberals?
Yeah, really.
Really?
Corporate people.
Nice AI newscast here.
Cast the ruling as the latest chapter in the majority's now completed demolition of the Voting Rights Act. Kagan pointed to another ruling involving Section 2 in which the conservative majority court in 21 endorsed Republican-backed measures in Arizona that a lower court said would disproportionately burden Black, Latino, and Native American voters. Kagan also cited a 2013 ruling authored by Roberts in a case involving Alabama's Shelby County that gutted Section 5 of the Voting Rights Act, a provision that had required states and locales with a history of racial discrimination to get federal approval to change voting laws. Wednesday's ruling, Kagan wrote, is part of a set.
Yeah, this is not, I mean, Yahoo News is not like the best thing. Do you know anything about this? I don't know anything about the FISA extension passed today.
I don't want to speak on.
It doesn't sound good. It doesn't sound good.
No.
I will have to investigate further.
But this is, again, an example of how much do I really care about this? If we lived in a functioning democratic republic, I might care. But
right.
The system is designed to keep you living in fear that if you don't vote a certain way, your life is going to get worse. Not how do I make my life better? I don't see anybody, and I mean anybody, even the very privileged people who love to go vote and being part of the team is such an important part of their daily lives. I don't ever hear anybody ever say, we elect these people, think we're going to have better lives. It's always be an adult about this and vote a certain way, because if you don't, your life is going to get worse. It's always defense. It's never offense. And if you ask me, that's one hell of a broken system if there ever was.